What is New York's zero-tolerance law? In Manhattan and across New York City, even a single drink before driving can have life-changing consequences for someone under 21. The zero-tolerance law embodies this strict approach by imposing swift penalties on underage drinking and driving to protect young drivers and their communities. The law applies to motorists who have not yet reached the legal drinking age and have even a small amount of alcohol in their system. It sets a blood alcohol concentration (BAC) limit of 0.02% for underage drivers, well below the 0.08% limit for adults. Violations are administrative rather than criminal for BACs between 0.02% and 0.07%. Drivers must attend a Department of Motor Vehicles (DMV) hearing and may face license suspension, civil fines and mandatory education. Once the BAC reaches 0.08%, the charge becomes a standard DWI, leading to arrest and potential prosecution. New York adopted this law in 1996 after statistics revealed that underage drivers, though less than 10% of all licensed drivers, were involved in about 14% of alcohol-related fatal crashes. Offenses fall into tiers. A BAC of roughly 0.02 to 0.04% triggers a zero-tolerance violation, addressed through a DMV hearing. BACs from 0.05 to 0.07% may result in a driving while ability impaired (DWAI) charge, a traffic infraction. BACs of 0.08% or higher lead to a DWI, which is a misdemeanor criminal offense. During traffic stops, officers administer breath tests. If the result falls within the zero-tolerance range, the driver receives a notice of a hearing instead of being arrested. Underage drivers do not face immediate suspension and may continue driving until the hearing decides the outcome. At the DMV hearing, the state must show that the driver was under 21, was operating a vehicle, that the stop and test were lawful, and that the BAC fell between 0.02 and 0.07% or that the driver refused testing. The driver can present evidence and cross-examine the officer. A first violation results in a $125 civil penalty and a $100 reinstatement fee along with a 6-month license suspension. A second violation carries another $125 penalty and revokes the license for a year or until the driver turns 21. To regain driving privileges, underage drivers often must complete the impaired driver program, which includes educational or rehabilitative components. Refusing a breath test can lead to harsher sanctions, including at least a 1-year license revocation and higher fines. Effective defense begins with scrutinizing the circumstances of the stop and testing. Police must have reasonable suspicion or probable cause to justify a stop. An unlawful stop may lead to suppression of evidence. Field sobriety tests such as the walk and turn and one-leg stand are subjective and can be affected by nerves or poor road conditions. Challenging how these tests were administered can weaken the case. Breathalyzer results depend on proper calibration and observation periods, and even minor errors in administration or maintenance can alter the outcome. A knowledgeable attorney reviews whether the driver was informed of their rights, whether proper protocols were followed and whether the officer's testimony is consistent. Because the burden of proof in an administrative proceeding is lower than in criminal court, strong legal arguments can make a significant difference. Even without a criminal record, a zero-tolerance violation affects insurance rates and stays on a young driver's record for years. Understanding the law and seeking counsel helps avoid missteps. Consulting with a lawyer early ensures that all potential defenses are explored and that the long-term impact on the driver's future is minimized. The Kugel Law Firm, located at 111 E 125th Street 2nd FL, New York, New York, 10035, provides guidance for underage DWI and zero-tolerance cases and represents clients at DMV hearings and in court. For assistance, call their office at 212-372-7218 and speak with an attorney who can help you navigate this process.